Arrest of ship under Nigerian law and international law. It is of tried knowledge that there are three basic means of transport. They include transport by air, transport by land, and transport by sea. Aeroplane is used for air transport. Motors and trains are adapted for land, road transport, while ship sails on the sea. Although there are aircraft constructed so that they can come down on and rise from water such as known as seaplane. Ships are often used for commercial and military purposes. In his great zeal for vocation in commerce introduced merchant shipping so as to reach out to other areas of the earth that are not accessible on land. Thus, the correlation between commerce and shipping dates back to the days of yore. Merchant shipping connotes shipping activities undertaken in furtherance of commerce and trade. Section 2, subsection 1 of the Merchant Shipping Act defines ship as any vessel other than a vessel propelled solely by oars or paddles, or a vessel which have been generally exempted from the provision of this Act by the Minister under Chapter 95 of this Act, or a vessel which has been partially exempted under provision of this Act by the Minister under Chapter 95 of this Act to the extent of such exemption. The Admiralty Jurisdiction Agree of 1991 provided its own definition of ship as mean a vessel of any kind used of constructed for use in navigation by water, however it is propelled or moved, and include a large, lighter, or other floating vessel, including a drilling rig, a hovercraft, an offshore industry mobile unit, and a vessel that has sunk or is stranded, and the remain of such vessel, but doesn't include a vessel under construction that hasn't been launched. A further definition of ship is that of the Admiralty Jurisdiction Procedure Rule 1993, which defines ship to include any description of vessel used in navigation. It is important to note that Chapter 95 referred to in paragraph B and C of the Section 2.1 of Merchant Shipping Act in relation to the definition of ship doesn't correspond with the subject matter of the exemption. Chapter 95 talks about reciprocity with other Commonwealth countries, while Chapter 96 talks about exemption of certain ships. It emphatically states that nothing in this Act shall apply to ships belonging to the government of the Federation or of a state, to ships of the Nigerian Navy or the Nigerian Naval Reserve, to ships of the naval force of any Commonwealth country other than Nigeria, or ships which belong to the government of any such Commonwealth country, to aircraft of the government of the Federation or of a state, to any aircraft which belong to the government of any Commonwealth country other than Nigeria, or are employed in the service of any such government. What emerged from foregoing is that the definition in the Merchant Shipping Act applies only to private commercial ships. Such distinction isn't found in the definition of Admiralty Jurisdiction Decree 1991, except that a vessel under construction doesn't fall within the definition of a ship, whereas Admiralty Jurisdiction Procedure Rules embraces in its own definition any description of vessel used in navigation. It therefore doesn't state whether government vessels are inclusive or exclusive. Prima facie, it could seem contradictory to the definition in Merchant Shipping Act. But Section 24.2, 3, and 4 clarifies the issue whether government vessels are inclusive in the proceeding commenced under an Admiralty Jurisdiction Decree. The principle of interpretation of stated enunciated in the case of Amadi versus NNPC 9 is to the effect that when the words of stated are sufficiently clear and unambiguous, they should be given their ordinary and unambiguous meanings. A maxim of statutory interpretation states that if stated specifies one exception to a general rule or assumed to specify the effect of a certain provision, other exception or effect are excluded. The expression of one thing is the exclusion of another. The effect of Section 24 of the Admiralty Jurisdiction Decree is that government vessel or naval vessel are excluded from the jurisdiction of the decree, and as such there is no contradiction intended whatsoever in the definition of Admiralty Jurisdiction Decree. Another issue that may be raised in the definition of ship is whether an aircraft could be clarified as ship in the admiralty practice in Nigeria. The Merchant Shipping Act defined a vessel as mean anything constructed or elsewhere for the carriage on, through, or under water of person or property and includes a hovercraft. Paragraph B of the definition clause in Section 2.1 of the Admiralty Jurisdiction Decree in relation to ships specifically mention a hovercraft just like the Merchant Shipping Act. This implies that the aircraft falls within the realm of admiralty practice. Nigeria is a new player in the maritime industry as against the European nation. Consequently, she might not have evolved a highly sophisticated maritime industry such as is obtainable in European nations. The maritime or admiralty law is still not highly evolved, as there are few cases contrary to the European. Admiralty or maritime law, according to Black's Law Dictionary, is that system of law which particularly relate to marine commerce and navigation, to business transacted at sea or relating to navigation, to ships and shipping, to seamen, to transportation of persons and property at sea, and to marine affairs generally. Modern-day codified admiralty law is a product of rules developed by sea merchants of old, which they evolved then to promote orderly international trade and sea transportation of goods and passengers, and the resolution of dispute arising from such endeavors. It must be noted that it is these admiralty practices that have developed into International Maritime Convention, which nation-state that signed such convention eventually adopted as national legislation to enhance such maritime industry, including Nigeria. Prominent among such maritime conventions are the International Convention relating to the arrest of seagoing ships of 1952, otherwise known as the Brussels or Arrest Convention. Ship arrest is as old as the maritime industry. As a colony of Britain, the British Admiralty law and practice applied in Nigeria until recently. The British Admiralty law and practice covered all aspects of maritime processes, including ship arrest. But Nigeria has also enacted maritime laws. Some of these laws that dealt with ship arrest include the Federal High Court rules, the Admiralty Jurisdiction Decree 1991, and the Admiralty Jurisdiction Procedure Rules. This statement contained provision on the practice and procedure relating to arrest and detention of ships. The maritime industry is international in character. Since the evolution of modern law of the sea, the international community has formulated rules and conventions with the object of harmonizing various aspects of maritime commerce. Ship arrest is therefore covered by international rules or conventions as well as domestic laws. The purpose of this work therefore is to x-ray the legal provision both in domestic law and international law regarding the enforcement of the arrest of ships. Nigeria was a colonial servant to Britain. The relationship that thus exists between the two countries particularly influenced the legal system of Nigeria. Britain had long ago developed a sophisticated shipping industry system, and as such, its legal system regarding the industry remained parallel with that of Nigeria. Thank you.